All right, so from here on out, if I follow this agreement, everything that you do, you need to ask yourself, is this something that could potentially result in me going to prison for 20 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. You understand?
Yes, ma'am.
This isn't a new case. It's a second chance on the line. A defendant already on deferred for aggravated assault now faces possible revocation, and one missed obligation could turn probation into years behind bars.
All right, court is calling 2022 CR 8631, State of Texas versus Jeremy Alvarez Pettz. Can I have parties announced for the record for the state?
Travis Banks to the state of Texas.
Defense?
Andrew Priest for the defense.
Are you Jeremy Alvarez Pettz?
Yes, ma'am.
All right, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Jeremy Alvarez Pettz who was placed on deferred adjudication in 2022 CR 8631 for the offense of aggravated assault with a deadly weapon on November 29, 2022 for a period of 7 years? Is that you?
Yes, ma'am.
All right, I'm going to need you to speak up, okay?
Yes, ma'am.
All right, state.
Violated condition number 4 in Bexar County, Texas. The defendant, Jeremy Alvarez Pettz, did then and there fail to report to the supervision officer as directed for the months of April, May, and June 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True. And the state will waive and abandon the other allegations.
Any objections?
No objection. Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes. Yes, ma'am.
Court will find violation of condition number 4 true. Is there an agreement?
Yes, Your Honor, the agreement, subject to the court's approval, is that the conditions be altered to deny the motion and alter and amend the conditions for state ISF, the cognitive track.
Is that the agreement?
That was our agreement, Your Honor.
All right, Mr. Alvarez Pettz. I will give you a choice. Sometimes I can't give people choices. It seems that you're not doing well on probation. So I can give you state ISF. Once you complete state ISF, you will still be on probation, or I can revoke you and I will sentence you to 4 years in the prison.
Your Honor. I'll take the ISF.
All right, so from here on out, if I follow this agreement, everything that you do, you need to ask yourself, is this something that could potentially result in me going to prison for 20 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. You understand?
Yes, ma'am.
All right, you want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record.
Jeremy Alvarez.
All right, why are you not doing well on probation? What's going on?
It's just when they switched my probation officer, I tried getting a hold of them, but I couldn't get through, so I just left it like that.
See, there's no excuse for that, because I tell everyone who comes in here that if there's an issue with probation and you feel like you can't get in touch with them or they're not addressing your issue, you can always come back to court and talk to me. And if what you were saying was true, all you had to do was come back to court. I would have been here, probation would have been here, and you would have said, oh, I can't get in touch with my officer. And I would have said, oh, let's see if we can get in touch with them now. Do you understand?
Yes, ma'am.
Probation. Is there anything he needs other than cognitive?
No, Your Honor, I think we really don't have a lot to go on since he did abscond. So we don't have any real back, anything there to give you, Judge. So I think if we start with state ISF cognitive, I think we'd be okay.
All right, the court is going to deny the motion, alter and amend conditions to include state ISF cognitive. And upon release, I'm going to want GPS, waive fees, and he's allowed to work. So it'll be partial for work only. And that GPS will be until further notice. All right, is there anything else you need from the court?
Not from the defense, Your Honor.
Now, let me explain something to you. If there's an issue with probation and you feel like they're not addressing it, you can always come to the court. You understand?
Yes, ma'am.
All right, good luck to you. All right, I don't have a trial court certification.
We were gonna ask for a continuance, Your Honor. We do have an offer. The
Mhm.
reason for the continuance is he's gonna get an immigration attorney because he's not a citizen. He wants to go over the offer and further. He picked up a new number one in Atascosa. So I'm filing my appearance today in Jordanton and trying to get all the evidence.
All right, and does he need an interpreter or no?
No, he speaks.
All right, Ms. Ferguson,
Yes, ma'am.
and you all are taking care of the immigration attorney?
I asked him today, he's hiring an immigration attorney.
Have you hired one?
Not yet, Your Honor.
When is this going to happen?
I'm gonna go today and try to hire one.
All right, Ms. Ferguson,
Yes, ma'am.
reset this for contested in December.
The seventh?
All right, we're coming back on December 7th, and this case is going to move forward.
Okay, and we're gonna most likely reach an agreement. I don't know, you said it was contested. I don't know if that matters.
Well, I mean, it's contested, but if it turns out it's not contested, then it's not contested.
Thank you, Judge.
All right, you're welcome. Ms. Ferguson will give you a reset form, then you excuse. So where are we?
Judge, this is where we're at. I've been conferring with Mr. Garahan regarding this case. He's not here today. Talked to Mr. Escobar. Discovery wise, we're fine. It's just a matter of us conferring about an offer. A state may come back and tell me, no chance, we're not gonna listen to my counter offer whatsoever. But I know there's discussion still going on. So whatever the court wants to do at this point, I don't know if you want to set it for one more pre-trial before we set it for trial or.
All right, Mr. Escobar.
Yes, ma'am.
Well, when will Mr. Garahan be back?
He'll be back tomorrow.
All right, we can recall it for next week. If that is good for you, counsel.
Yeah, always good, Judge, whatever you like.
So what's a good date for you next week?
About Thursday, October 26th.
All right, Ms. Ferguson, can we bring back Mr. Martinez on October 26th? All right, we'll recall you back on October 26th. Okay,
Thank you, Judge.
all right, thank you. Are you all prepared to proceed or no?
We are, Your Honor. It's a motion to revoke. We have an agreement.
Okay, Mr. De Leon, I need a trial court certification.
I'll get that for you, Judge.
Okay. Norma, do you have a highlighter?
Yes.
Thank you.
Did you have that form for you?
All right, thank you. All right, thanks. All right, court is calling 2020 CR 11096, State of Texas versus Joe Pettz III. Can I have parties announced for the record for the state
Laura Metzel for the state.
defense?
Michael DeLeon from Mr. Pettis.
And are you Mr. Pettz?
Yes, Your Honor.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amended Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Jose Pettz III who was placed on deferred adjudication in 2020 CR 11096 for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on July 20th, 2021 for a term of 4 years? Is that you?
Yes, Your Honor.
All right, state.
Your Honor, on the first amended motion to adjudicate probation, violation condition number 1, on or about the 7th day of September 2023 in Bexar County, Texas, the defendant Jose Perez III committed the offense of possession of controlled substance in violation of condition number 1.
All right, how do you plead to that? True or not true?
True.
And then violated condition number 1, on or about the 8th day of September 2023 in Bexar County, Texas, the defendant Jose Perez committed the offense of possession of controlled substance in violation of condition number 1,
How do you plead to that? True or not true?
True.
and will waive the remaining violations, Your Honor.
Any objections?
No objections, Your Honor.
Did you understand by pleading true to violations 1 and 1, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison, and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish pleas true to violations 1 and 1?
Yes.
Court will find violation of condition 1 and 1 true. Is there a proposed agreement?
Yes, Your Honor, to alter and amend the conditions of probation with referral to drug court with SATIF, followed up with SATIF aftercare, biweekly UAs, sober support meetings 2 times per week, and the TDOEP class.
Okay.
And as part of this agreement, we'll be TICing 2 new cases. Night mag number 729016 and 729015.
That's correct, Your Honor. That's our agreement.
All right. Mr. Pettz, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Jose Perez III.
All right, so what drugs are you using?
I'm using methamphetamine
All right, how often?
every month. Every day, basically.
All right, so here's the thing. You got to be honest with me
Yes, ma'am.
because they've come to an agreement. I'm inclined to follow it, but in order for me to follow it, I need to give you conditions. So hopefully, whatever your issues are, you can get a control of them. You understand?
Yes, ma'am.
So you're using meth every day?
Yes, ma'am.
All right. Felony drug court is at capacity. But I think you need inpatient treatment, which is what everybody's suggesting you need.
Yes, Your
So
Honor.
what I can do is I can deny the motion, alternate main conditions, and I'll have you go to SATA. And I'll ask probation to make sure that you're still referred to felony drug court. So maybe once you're released from SATA, you can go into felony drug court.
Yes, Your Honor.
So even though SATA will address some issues, I don't think that's going to be enough for you with a daily meth use. I think you'll need felony drug court as well. Do you understand?
Yes, Your Honor.
All right. This is what the court will do then. The court will deny the motion, alternate main conditions to include SATA with aftercare and a referral to felony drug court. Taking consideration NIMAC number 729016, 729015. And there'll be daily sober support meetings until accepted into felony drug court. And I know that seems like a punishment, but until you're accepted in felony drug court, you got to keep your mind busy and you got to keep your mind on your sobriety 100%. It can't get distracted at all because otherwise you'll probably be back here again for a possession of a meth case. And I understand the only difference from somebody possessing meth who has a drug problem is they didn't get a chance to use it. So understand?
Sure.
Is there anything you need from the court to be successful other than what we've given you?
No, ma'am.
All right. Thank you.
Thank you.
Thank you, Judge.
Thank you. All right, court is calling 2023 CR 6932, State of Texas versus Johnny Guy Ramirez. Can I have parties announced for the record for the state?
Hank Wilkins, Judge.
Defense?
Robert Featherston.
All right, we're here for Johnny Ramirez for sentencing today. Off the record, defense counsel was telling me that he was going to ask for a continuance. Did you file a motion or no?
No, Judge, no motion was filed. I literally just found out that the surgery has not yet taken place.
All right. State, any objection to the defense's oral motion for continuance?
No, Judge.
All right. Court will hear argument.
Your Honor, if it pleases the court, the child has an appointment in Houston for evaluation for brain surgery on November the 3rd. We're respectfully requesting that the court allow him to come back November the 10th for sentencing. He's already been admonished that the full range of punishment is available if he doesn't appear for sentencing.
All right. So, state, are you going to have any objection?
Just the same admonishment, Judge, the full range, and I would ask the court to remind the defendant that if you are inclined to grant this, that's the day.
All right. So here's my question. Counsel, you're an officer of the court. Do you have proof of this? Proof of the fact that there is a brain issue with his daughter? Do you have proof?
Judge, I have not had any independent investigation on my part. The representations made by his wife are what I am relying on. That the child has to go to Houston on November the 3rd.
All right, so with regards to her issue, does anybody have any medical documentation whatsoever?
My wife does.
All right, so he says his wife has medical documentation. Counsel, if you could go take a look at that documentation and tell the court if it's appears to be true.
Thank you, Your Honor.
Yes. All right, we're gonna go back on the record in 2023 CR 6932. Oh, if you can come forward, Mr. Ramirez.
Your Honor, please report. I'd like to call Valerina Flores, the child's mother.
All right, so I know you're gonna call her as a witness, but, and I will hear from her, but is there any documentation that you've seen?
I believe there is, Judge.
Okay.
The terminology is medical terminology. It doesn't say brain surgery, but it does list her maladies.
Okay,
And if the court will allow me, she'll bring up the online medical record and can tell you what the different diagnoses are.
all right, we can bring her up, but counsel, I mean, you've looked at it, I'll take your word for it, but if you want to bring her up as a witness, we can.
Well, we might as well get on the record what those maladies are.
Okay, sure. And what is her name?
Valeria.
I'm sorry,
Valeria.
Valeria. All right, thank you. All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Valeria Flores.
All right, defense.
Ms. Flores, if you would take a look at the online record in the section where it lists what the evaluations are on your child. A little further down. Right here. Can you read those out, please?
She has left hemiplegia.
All right, just 1 second. Let's do this. If you can move closer to the court reporter.
Okay.
And when you state whatever you're stating, if you can spell it, that'll
Okay.
make it easier for her. Okay.
Okay. Left hemiplegia, it's LEFT. Hemiplegia is HEMIPLEGIA.
And just spell it a little slower.
HEMIPLEGIA.
Yes.
Seizure disorder. Left hemiparesis. Left, and then hemiparesis is HEMIPARESIS. Cerebral palsy. Closed fracture of shaft of right clavicle. Closed fracture of shaft of clavicle. And then elevated blood pressure reading without diagnosis of hypertension.
Your Honor, to please support, those are what are listed in the medical records.
All right. Thank you so much for letting us know. Okay.
Right.
Your Honor, may she be excused?
Yes. Oh, I'm sorry. When is the surgery or when are you all scheduling things?
We just did a 48-hour EEG to determine where her seizures are at, and come to find out it's her entire brain. So November 3rd, the doctor wants to talk with us with a colleague in Houston,
Mhm.
just to get a better understanding of what type of surgery they're going to perform.
All right. And how old is she?
She's 16.
All right. We're going to be praying for her.
Thank you so much.
You're welcome.
Thank you.
All right. If we can go off the record for a moment. Thing that needs to be done is the plea page.
Yes, ma'am.
So if you guys want to just print that out and write that in, you can.
Thank you.
Oh, and counsel, the application.
We'll do.
All right. Hello, Mr. Rodriguez. Oh, I'm doing great. How are you doing today? Okay. All right. Today is your plea deadline date. So this is the day where you let the court know whether or not you're accepting the state's offer or not. You understand? All right. So do you want a jury trial? Or are you accepting the state's offer?
I'm not gonna accept the state's offer.
All right. So you want a jury trial? All right. How long do y'all expect this trial to last?
2 to 3 days, Judge.
And he's not 2 to 3 days. He's saying 2. All right. And I've known Mr. Callahan for how many years? And if he says 2, yeah, if he says 2, it's 2. All right. And I'm assuming you all will be proceeding on the first degree. Is that correct?
Yes, Your Honor.
All right. Ms. Ferguson, they need a jury trial and it's for 2 days.
December 5th.
All right. Mr. Callahan, December 5th.
Yes, ma'am.
All right, we're going to put you at December 5th. We don't have juries the week of Thanksgiving and our docket is booked, okay?
Yes.
All right, so that's the quickest I can get you in.
That's fine.
All right, is there any discovery issues? I know last time there was not.
No, Your Honor.
All right, if you all do a discovery acknowledgement before you leave on the 3 cases,
Yes,
and
Judge.
then just let Mr. Callahan know which case you're proceeding on.
Yes, ma'am.
All right, thank you. Court is calling 2023 CR 6932, State of Texas versus Johnny Guy Ramirez. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Robert Featherston is representing Mr. Ramirez.
All right, are you Johnny Guy Ramirez?
Yes, ma'am.
All right, it's the court understanding is that both the state and the defense have entered into a new plea bargain agreement. Do you understand that?
Yes, ma'am.
And is that correct, state?
Yes, Your Honor.
Correct, defense?
Yes, Your Honor.
All right, so the same admonishments that I've given you before apply. Do you understand?
Yes, ma'am.
And are you waiving your right to trial?
Yes, ma'am.
So with regards to the enhancement, which enhancement is he pleading true to?
It's the first, in the paperwork, it's the first one, Judge. It's cause number 2013 CR 1015.
Right. And how do you plead to that enhancement? True or not true?
True.
All right. With regards to the plea bargain page, did you review that page with your attorney? Did you understand it?
Yes.
All right. So according to the plea, you agree that you've been previously convicted of enhancement, paragraph 1. The punishment is to be assessed at 10 years in the prison. The state is silent on your application. Did you understand that to be the case?
Yes, ma'am.
All right. And defense, is that the plea?
It is, Your Honor, with this application for deferred.
All right. And state, is that the plea?
Yes, Your Honor.
I'm going to show you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
And then state, it's the court understanding as well. And we're going a little bit out of order here because there's been a new plea bargain agreement reached. But state, are you offering into evidence state's exhibit number 2, which is the judgment?
Yes, Your Honor.
Any objection?
No objection, Your Honor.
All right. And outside the agreement, the state is requesting a TAP evaluation. Did you understand that was a recommendation from the state and the court does not have to follow that recommendation?
Yes.
All right. You previously pled guilty. Do you still wish to enter a plea of guilty?
Yes.
All right. State, do you have any evidence to support this plea?
Your Honor, I offer state's exhibit 1 in the attachments.
No objection, Your Honor.
All right, the court has previously reviewed that. Mr. Ramirez, do you understand the previous admonishments that the court gave you with regards to state's exhibits 1 and 2?
Yes.
All right. The court has reviewed states exhibits 1 and 2. The court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Do you understand that in regards to your application for deferred adjudication, if the court were to grant that, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison?
Yes, ma'am.
Knowing that, do you still wish to apply for deferred adjudication?
Yes.
All right. Is there anything you wish to say on behalf of your client?
Judge, the court and the state are both being very kind. He has accepted responsibility for his actions in this case. And we respectfully request that the court follow the plea agreement and give him a deferred.
All right. Are you employed?
Actually, no, ma'am, I'm not right now.
All right.
Take care of my kids at home.
I'm sorry.
I'm taking care of my kids at home,
All right. How old are your children?
2 and 3.
And the 16-year-old?
She goes to school. She goes to school, and my other daughter goes to school too.
All right. If you're drug tested today, what are the results going to be?
Well, I am still dirty.
Dirty for what?
For both meth and for marijuana.
All right. So you shouldn't still be dirty for meth and marijuana since this plea was originally taken on October 13th. So it's clear to the court that you have a drug problem.
Yes, and nobody's ever given me no treatment.
No. We're doing this one step at a time.
Okay.
So you have a drug problem.
Yes, ma'am.
Your problem is with meth. And you're not any good to anyone if you're using meth. You're not good to your daughter who has this brain issue and that's going in. You should not be allowed to be taking care of a 2-year-old and a 3-year-old. And I'm not going to allow that.
I don't do it like when I take care of them and stuff.
No, right now, you should not be allowed to take care of 2-year-old and 3-year-old. Let me ask you this question.
Yes, ma'am.
Let's say you need a babysitter, right?
Yes.
And somebody has recommended me to you. I come out, I meet the family. Everybody says, oh, Stephanie's great. So I come out to your house and you and your wife say, you know what? We're going to see if the children like her. Children love me. I'm the Black Mary Poppins. You all take a break. You said, we're going to test her. We're going to turn on cameras and we're going to tell her we're going to the store. You go to the store. I'm still the same great person. And you come back and the children are like, please, can we keep the Black Mary Poppins? And you guys say yes. So you all decide to hire me. And I'm like, oh, I'm so excited. And then as I'm walking out the door, I said, you know what? You guys seem like a nice family. Your children are nice. Let me just tell you something about myself that nobody knows. And I tell you, I use meth and marijuana, but don't worry. I'm not going to use meth and marijuana over the children. I will do it before I come. Are you still going to let me be a babysitter? I'm sorry?
No, I wouldn't.
That's what you're doing. So I'm not going to allow it.
I pick all that stuff.
So you're not going to be allowed to take care of a 2-year-old and 3-year-old. You understand? And you need to get a job. There's no excuse for you not having employment. And if you're on deferred out of this court, I require people to have employment. And would your wife test positive?
No.
So here's the thing about that. Your wife then, since she won't test positive, she's holding everything down by herself. She has employment. She's dealing with her daughter who has these medical issues that she has to take to Houston. She can't depend on you to drive to Houston because you're using meth and drugs. She has a 2-year-old, 3-year-old. She can't depend on you. So right now you're not bringing anything to the table. But when you're on deferred adjudication out of this court, you're going to bring something to the table. You understand?
I promise you I will. And change.
All right. It's going to be 10 years deferred adjudication. We're going to do a TAP evaluation. And he's going to follow TAP recommendations. So if it recommends inpatient treatment, you're going to inpatient treatment. And the fact that your daughter has a medical issue, you're still going into inpatient treatment. You understand?
Yes, ma'am.
And counsel, if you can see, maybe Lifetime Recovery will accept him into their inpatient program.
I'll check on that, Judge.
All right. There is going to be the UA hotline, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. Doesn't matter if it's your child or not, you're not to have unsupervised contact with them. So there needs to be an adult if you're going to be there. And if the adult says, I need to go to the grocery store real quick, you take care of the children, you better tell them no. You understand?
Yes, ma'am, I will.
I'm going to want field visits one time per month until further notice or until he's at the Lifetime Recovery Residential. Regular reporting by Zoom or in person. $200 hours of community service restitution. That will be waived upon completion of parenting classes. And probation, whatever parenting classes you all deem is necessary. All right, probation, is there anything else he needs?
Oh, no.
All right, is there anything else you need from this court to be successful? Do you need anything else to help you not come back here for a revocation? All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, so off the record. From here on out, everything you do in your life, you know what you need to ask yourself some questions before you do it. One, is this something that could potentially result in me going to prison for 20 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. The only reason why you have this agreement before you right now is because of your daughter's medical issues, not because of anything that you have done. So you had better take this opportunity to do better and not use drugs. All right. Good luck to you.
Thank you, Your Honor.
You're welcome.
The court granted 10 years deferred adjudication, but with intensive treatment, supervision, and no unsupervised contact with his children. This wasn't just mercy, it was accountability tied to rehabilitation. Would you have given him this chance?
All right. So has an offer been tendered?
Yes, Your Honor.
All right. Was that tendered today?
I think it's the first time we've spoken about a judge.
Yes, Judge. I believe that's the first time I've seen that offer in the file. So we reset from the last setting in order to get, he's on parole, in order to get more clarification on what he can and cannot do in order to not mess up on parole. We've gotten that clarification, spoken to the state. They need to look further into it before they can make the offer that we're asking for. So we're just asking for a reset to give them that time.
All right. And how long is that going to take?
I think a month would be reasonable, Judge.
And if they get me the offer in the meantime, the offer would end up being a plea to the misdemeanor and a dismissal on this. So we'd end up getting that set. That way we wouldn't even be back on the next setting on this one.
All right, Ms. Ferguson on MC Reed, if I can have a 30-day reset.
Yes, ma'am, the 27th.
All right, we'll come back on November 27th. Once you sign the reset form, you're excused. Mr. Reed, you need to make sure you're on time next time, okay?
Yes, ma'am.
All right. So what does the MC stand for? I know we had this discussion.
It's my real name. I'm a junior.
Oh, okay.
Okay.
Awesome. But see, I always think that letters MC have to mean something.
In most cases, they do stand for stuff, but in my case, I guess the generation that was before me, they just use letters sometimes.
Okay.
JB or JL.
Ah, okay. Now when you said JB,
Yeah.
I understand now.
Yeah.
Okay, awesome.
Yes, ma'am.
All right. Once you sign the reset form, you're excused.
Thank you.
All right, you're welcome. Court is calling 2023 CR 7145, State of Texas versus Ricardo Tavares, could I have parties announced for the record for the state
Jason Garahan, Your Honor.
defense?
For the defense.
And are you Mr. Tavares?
Yes, Your Honor.
Counsel, have you received all the discovery and did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Tavares, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving count 1, 3, and 4, and proceeding on count 2 alone.
Any objection?
No objection.
Mr. Tavares, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? In count 2, you're charged with the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams. That is a second-degree felony. Off the record for a moment. Probation, this is no application. And we're back on the record. The range of punishment for that offense is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Tavares, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Honor. Yes, Your Honor.
According to the plea, the state is proceeding on count 2. There are no applications, and they're asking that your punishment be assessed at 3 years in the prison. Did you understand that to be the plea?
Yes, Your Honor.
Defense,
Yes, Your Honor.
state,
It is, Your Honor.
showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it?
Yes, Your
Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
There were none, Judge.
Then to the offense as charged in count 2, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Yes, Your Honor. State Exhibit number 1 with all the attachments.
We have no objection.
All right, state, you may continue to confer. Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, and laboratory reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding in sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Just ask to follow a plea agreement.
All right, court will follow your agreement. The court will sentence you to 3 years in the prison, give you credit for any time served. Is there anything else with regards to sentencing?
Nothing further, Your Honor.
All right, Mr. Tavares, I'm showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. How old are you?
I'm 35.
All right, do you have any children?
Yes, I do.
All right, here's the thing. You know that life keeps getting short for people. I can say that I'm in the twilight of my life. You're going to have to make a decision on if you're going to change or if you're going to spend the rest of your remaining time on this earth in and out of jails, in and out of prisons. I'm sure your children would love for you to be clean and sober in their life. If there's a drug or alcohol problem, there are plenty of free places. If you would like, I could actually have you referred to the therapeutic community at the prison. It will not increase the length of time that you're in prison. So for example, if they're going to parole you at 2 years, they're not going to say, we're not going to parole him because he's in the therapeutic community. It's just something to get you on the right track. Would you like that?
Yes, Your Honor.
All right. Caroline, can I see the following Tavares again? All right. Well, good luck to you. Okay.
Thank you.
All right. Good seeing you. Yes. Court is calling 2023 CR 0923, State of Texas versus Cornelia Shalom Childress. Could I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense.
Let's Christian.
And are you Cornelia Childress?
ma'am.
I'm going to show you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Cornelia Childress who was placed on community supervision in 2023 CR 0923 for the offense of felon in possession of a firearm on May 30th, 2023 for a term of 4 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 1 on or about the 24th day of August 2023 in Bexar County, Texas. The defendant Cornelia Shalom Childress committed the offense of possession of controlled substance, penalty group 1, and violation condition number 1.
How do you plead to that? True or not true?
No contest. Okay, true.
I'm sorry. So to violation of condition number 1, how do you plead?
True.
Right.
We'll waive the remaining violation.
Any objections to state's waiver? All right. Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 4 years in the prison and up to a $1,500 fine?
Yes, ma'am.
Knowing that you still wish to plead true to violation of condition number 1.
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is. It is to revoke the individual off for probation and to reform the underlying sentence of 4 years to 3 years in Texas Department of Correction, and the state will take into consideration cause number or nightbag number 726987, which she pled true to.
All right.
That is our agreement, Judge, and we'd just like to tell the court that she has 284 days credit that she would like to add for.
All right. Are you asking the court to follow this agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right. The court is going to find violation of condition number 1 true. Court will grant the motion, sentence you to 3 years in the prison, give you credit for any time served, take in consideration nightmag number 726987. All right. If you all are behind, I make this announcement every time. If we're on the record and you're behind the court reporter, just ask to move to the other end. All right. Ms. Childress, I pronounce sentence. If you would like, I can ask them to refer you to the therapeutic community. It doesn't increase the time that you're in custody, but it could potentially help you get on track with your life. Would you like that?
Yes, ma'am.
All right, so I'm going to order the therapeutic community. You'll still need to ask for it when you get there because I have no jurisdiction to force them to place you in the program.
Yes.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, ma'am.
All right, we can go off the record. I see that I ordered parenting classes for you.
Yes, ma'am.
You are going to have to get your life together, because if you don't, somebody else is going to be raising your children, right?
Yes,
And I always tell people a mother's love is different from other person's love. But if you have no plans on improving your life, don't come in and out of your children's life. You understand?
Yes, ma'am.
All right. Good luck to you.
Thank you, ma'am.
You're
Thank you, Judge.
welcome.
May we be excused?
Yes.
Thank you.
Morning.
Good morning. How are you doing today?
I'm doing well. How are you?
Oh, I cannot complain. It's a beautiful day.
Yes, ma'am, it is.
The sky acts as though we're trying to get some cool weather. LSU won, so I don't know what else we can say about that.
We're rolling in just as much as everybody else.
All right, so on this case, All right, state is to make an offer. State, did you make an offer?
Yes, Your Honor.
All right, we're going to recall this in 2 weeks. In 2 weeks, you need to let the court know if you're accepting the offer.
We can do that, Judge, but in the meantime, I did want to bring something to the court's attention. There has been, I've been out the last month, but in my absence, there was some issues that arose from Ms. Gutierrez's case with her family, and she was recently released from Laurel Ridge.
Okay.
I believe, just based on some communications that have occurred, and just, I would like to be cautious. I would request if we could be referred for an evaluation for competency for Ms. Gutierrez.
Okay. All right, Ms. Ferguson, on this case, give me a 45-day reset, and we need to refer her to Judge Carruthers for a competency.
We can do December 7th.
All right, and Ms. Ferguson, if you'll make sure that's filed.
Yes, ma'am.
All right, do you want the court to file that, or are you going to do it?
For the
Competency.
request for competency, I can file that later this afternoon if the court. if the court
Well, they
wishes.
will file it later this afternoon.
Thank you.
All right, thank you.
Thank you.
You're welcome. Once you get the reset form, you're excused.
Yes, Judge.
Thank you. All right, we're here for discovery on the body cam. Where are we on that?
So I did receive the discovery for body camera early on, Your Honor. In this case, the issue was that of witness names for information that was discovered on one of the body cameras. I guess the state can update. Well, I think they essentially hit a point in this case where it may require further investigation from the defense potentially, or maybe a motion. But in the meantime, the state has extended an offer. We would request, just given these circumstances, if we can be given a plea deadline for Mr. Camacho.
All right, Ms. Ferguson, if I can have a 30-day reset on this case for plea deadline date, and it's Camacho.
The 28th.
All right, we'll be back on November 28th. Once you sign the reset form, you're excused.
Yes, ma'am.
All right,
you.
thank you. So we are here today for a jury trial date.
Your Honor, it was my understanding this was a status update, because there was some discovery, and I do need to inform the court that pursuant to 3914 and Brady, we learned some information this morning. We will need to interview a prospective witness, and so we're asking for another, at least two witnesses that we know. So we are asking for another discovery setting.
I'm giving you guys a jury trial date. This has been going on with discovery since June 9th, 2022. So it's been all this time for discovery. I realize defense attorney's been changed, but we were here for discovery in June. Then we had discovery in August, and that discovery was related to the autopsy, which I know none of you indicted a case without an autopsy, but that's neither here nor there. Then we come back in September. In September, another discovery issue with autopsy. Then we come back on December 1st. Then we have DNA comparison that needs to be done. Then we come back on February 3rd. Then we come back on March 2nd. Then we come back on April 4th. Then we come back on April 12th. Then we come back on May 25th. Then we come back on June 1st for a plea deadline date. Then it gets recalled for June 5th because we have this whole attorney issue. Then we come back on June 5th. It was supposed to be a jury trial, but then no, we reset it for October 3rd. And then we say, all right, we're going to recall for October 23rd. I granted a motion for continuance. And then this date is the day that we get a jury trial date. So whatever you all want to do on off docket, whatever y'all want to do in Brady, y'all want to talk to some witnesses, then y'all talk to those witnesses. But you all are getting the jury trial today, and you all need to handle whatever discovery you all need to handle off docket.
Judge, may I say something?
Sure.
I know when we hear that from you, it sounds like, what are y'all doing? And it really is a case that's not, what's the right word? It's simple. It's not simple. The discovery and evidence is evolving because of the complexity of it. Now, if these witnesses have exculpatory information, obviously we want that and we want time to deal with it. Right now, they don't know exactly what the nature of it is, but.
So here's my question. When were these witnesses discovered? And did these witnesses just drop out of the sky, somebody indicting cases without
But they don't.
talking to witnesses?
Your Honor, this particular witness, I believe.
Yes, he was a fugitive judge. I did personally indict the case. I did have an autopsy for the record when I indicted the case. However, this witness, no one was able to find him to interview him. He has now since picked up criminal cases. This morning, we were able to meet with his attorney. We have not met with him. We met with his attorney.
So where is he?
He is in custody.
At the Bexar County Jail?
Correct.
So then those witnesses' statements should be able to be done this week. So next.
But that's taking it, you've got his attorney that has to talk to him and then make him available to meet with them. I mean, it all takes time, as you know.
Today is Monday. That needs to be done this week, or however you guys going to do it.
And then there's another issue too, which is that we have, the discovery's massive. And we have, external terabyte number 1 that we have received. And we have external terabyte number 2 that was handed to us unopened and unviewed. And because of content, possible content on there, it was returned to the DA's office. Okay, so there's a second 1 terabyte hard drive that is not in the possession of the defense, but available to the defense to view. The fact that we can't possess it and we have to go to the DA's office to view it also is a time-consuming thing.
Oh, let me just tell you, the state is going to be available whenever you all are available to go over there. And if you all want to set a setting in this court to come down and view it, you can set a setting in this court to come view it. How long have you been in custody? A year and 10 months. This is going to trial before the new year. Ms. Ferguson, give me a trial date for this case before the new year. How long do y'all expect this trial to last?
2 weeks.
All right, it's a 2-week trial setting.
I would say today's October 23rd, 22nd.
So everybody have all the month of November and the end of this month. What date, Ms. Ferguson?
So it's December.
December 12th, Judge.
All right, December 12th.
Judge, is that not going to put us into Christmas if it's a 2-week trial?
Yeah,
They'll be here for Christmas. All righty, thank you all. Hello. Are you not hot?
No, I was really good in the sweater.
Oh, okay. All right, so what is happening on this case?
Yes, Your Honor, the state has made an offer of mental health PTD on one of the misdemeanor cases. Once we are going to ask for a reset so we can apply into that course.
Okay.
And once he gets accepted, then I believe this felony case is going to be TIC'd along with all the other thefts.
All right, Ms. Ferguson, so you're doing PTD in misdemeanor court?
Yeah, yes, Your
All right, can we reset this for 30 days for an update on the misdemeanor PTD?
And Judge, just to clarify, it's gonna be the mental health court PTD.
Yes.
Mental health court, okay. What date, Ms. Ferguson? Yes, it's for mental health. All right, we'll come back on November 30th to see where we are. Once your client signs the reset form, you're excused.
Thank you, Your Honor.
You're welcome.
The court reset the case to allow mental health court screening, a path that could resolve both misdemeanor and felony matters through structured treatment instead of incarceration. Do programs like this reduce repeat offenses? If this case caught your attention, share your thoughts below and subscribe for more courtroom breakdowns.